two of them in Lake Sinai one year. It was spring, and the fish houses were all off, and they'd walked out. And when they were coming back in after dark, they crossed where there had been another fish house and fell through because ice was thinner there.
Well, I know.
And then the second guy tried to get the first guy out, and both ended up.
Call the meeting to order. And just want to announce that this meeting is being televised and recorded. First item on the agenda is the approval of the minutes of the March 7th, 2019 meeting. The minutes were sent out ahead of time. Is there any additions or corrections to those minutes? If not, we need a motion to approve.
So move.
Second.
Motion by Ford, second by Spence. All those in favor say aye.
Aye.
Opposed? Carried. Items to be added to the agenda by commission members or staff. Does Richard?
We just want to do the director's report at the end of the meeting.
Okay. No one else have anything? Okay, we'll move on. Invitations for citizens to schedule time on the commission agenda for an item not listed. This time is limited to 5 minutes per person to address the board. Is there anyone in the audience that would like to talk to anything that's not on the agenda tonight? Seeing none, we'll move on. Disclosure of conflicts of interest. Does anyone have a conflict of interest with anything on the agenda tonight? Seeing none, we'll move on. We need a motion to approve the agenda as read.
So move.
Motion by Bartley,
Second.
second by McHugh. All those in favor say aye.
Aye.
Opposed? Motion carried. Let's see. What's that? Oh, there it is. Okay, I need to read the opening statement. The Brookings County Planning Commission is a 9-member commission whose function is to recommend approval or disapproval of land use plans, zoning ordinance, subdivision plats, and amendments thereof to the Brookings County Commission. The Commission makes its recommendation based upon the adoptive comprehensive plan for the physical development of the unincorporated areas of Brookings County. As a matter of policy, all motions are made in the positive. After a motion is moved and seconded, it is open for debate. Those supporting the motion shall, in turn, give their reasons. Those opposing the motion shall then offer their reasons. After everyone has been given a chance to be heard, The commission shall recommend approval or disapproval based on the testimony and information presented. A simple majority vote of a quorum of members of the Planning and Zoning Board in attendance is required to forward a recommendation. And with that, consideration of plats. 2019 Plat 005, plat of Lot 4A, Block 2, Sunset Point Addition and Government Lots 3 and 4 of Section 22, Township 112 North, Range 47 West of the 5th Prime Meridian, Brookings County, South Dakota. Is there a motion to approve?
So moved.
Motion by McHugh. And a second?
Second.
Second by Ford. Richard?
Yes, 2019 Plat 005. It's a plat of Lot 4A in Block 1 of Sunset Point Addition. Sunset Point Addition is located at Lake Hendricks. It was originally platted and approved by the Zoning Commission on November 1st, 2005 into lake lots meeting the 20,000 square foot requirement. On October 2nd, 2012, all the lots that were platted in 2005 and were not sold were replatted into larger lots for tax purposes. They have sold a lot, and Lot 4A is being replatted into the individual lake lot like it was originally platted. Here's the plat. This is Lot 4A right here, coming up along East Lake Hendricks Drive. This goes out to County Road coming in from the south. This was the original plat, 2005, where these lots were all platted into individual lots. Then they unplatted, vacated all of those lots that weren't sold, and now they've sold this lot and they've platted it right back to the same exact size as it was originally platted. So it meets the 20,000 square foot requirement. This is just a beacon map with the proposed lot in there showing the rest of the open lots, unplatted lot right here. Sunset Point Addition is over on this side. This is existing lots over here, back lots on this side that have been there quite a while. It's just the beacon map right here showing the proposed lot. And that's all that I have.
Okay, thank you, Richard. Is there a representative here for Lake Dreams?
No, they were not able to make it this evening.
All right. Questions or comments from the board? Open it up to the public. Questions or comments from the public, for or against? Seeing none, we'll close the public portion and go back to the board. This is pretty straightforward. Anyway, questions or comments? Seeing none? Richard, call the roll.
Bartley,
Aye.
McHugh,
Aye.
Elankowicz,
Aye.
Erickson,
Aye.
Kleinjohn,
Aye.
Ford,
Aye.
Spence,
Aye.
Jensen,
Yes.
and Rochelle.
Aye.
Motion passes. Yep, you can go on.
Now, we're now acting as the Board of, the Board of Adjustment. I need to read the opening statement. Board of Adjustment is a 9-member board which has the power to hear requests for variances, conditional uses, appeals, and special exceptions. The concurring vote of 2/3 of the attending members is necessary for approval of any action by the board. A 9-member board requires 6 votes. A 6-member board requires 6 votes. In accordance with Robert's Rules of Order, we require a motion to approve a request before the request can be debated. As a matter of policy, all motions are made in the positive. The board, under specific powers granted by the state, shall authorize variances from the zoning requirements where special conditions existing on the land will result in unnecessary hardship for the applicant. Financial disadvantage to the property owner shall not constitute proof of unnecessary hardship. With that, move on to agenda item number 8, 2019 variance 002. David Squires has made an application 2019 variance 002 to the Brookings County Board of Adjustment for a variance. Article 4, District Requirements, Chapter 4.03 LP, Lake Park District, Section 4.03.03, Density, Area, and Yard Regulation, Minimum Lakefront and Minimum Side Yard. Property described as Lot 42 of DeBoers Lake Tatanka West Subdivision in Government Lots 1, 4, 5, and 6 in the southwest 1/4 of Section 7, Township 111 North, Range 51 West, which is Oakwood Township, located at 64 Oakwood Shoreline Drive, Bruce, South Dakota, 57220. And with that, is there a motion to approve?
So moved.
Motion by Lankowicz, and we need a second by McHugh. Richard?
Yes, 2019 VAR 002, David Squires has applied for a variance to build a 20-foot by 32-foot residential addition with a 16-foot by 36-foot attached deck 24 feet from the high water mark, a variance of 51 feet, and 6 feet from the southeast side of the side property line, a variance of 2 feet. The Lake Park lakefront setbacks are 75 feet from the high water mark and 8 feet from the side yard. The proposed addition and deck will be in line with the neighboring properties on either side of his property. The current cabin was built in 1974, prior to the Lake Park current setback requirements. It is 20 foot wide and 32 feet long, with a 16 by 16 foot addition and a 12 foot by 34 attached deck, 32 feet from the high water mark. The 16 by 16 cabin addition is no longer structurally sound. The cabin is built on a ridge and sits 68 feet above the high water mark. A portion of the parcel is in the floodplain, and the applicant will need to complete a floodplain development permit and follow FEMA floodplain standards for the proposed addition. The current site plan and proposed site plan were included in this report. DeBoers Lake Titankaha West Subdivision was originally platted in 1984 and replatted in June of 2003 when the original road was vacated and relocated. The Brookings County Comprehensive Plan planned future land use development lakes for future land use found on page 58 in paragraph 2. It is likely that the established development of area lakes of Lake Campbell, Lake Hendricks, Lake Titankaha, and Lake Poncet will experience continued development in varying degrees. While non-lakefront growth potential exists for all of the able lakes, significant lakefront area is appropriately zoned and some divided in some cases, adjacent to Lake Titankaha, Lake Hendricks, and Lake Campbell. Letters were sent to the adjoining landowners and the Oakwood Township Chairman and Clerk. Public notices were published in the Brookings Register on March 19th and 26th, 2019, and the Volume Tribune on March 21st and 28th. Just a copy of the variance application. Proposed site plan. There's the existing house proposed new addition, coming out 20 feet, going the entire length of the house here, and then a proposed deck coming out 16 feet, and out 36 feet with a 4-foot walkway along the side of the house, and it'll meet 9 foot on the northeast side of the house, and this will be 6 feet on the southeast side of the house. For the current house, that's the existing setbacks for the current house to the adjoining property line. Just a proposed floor plan. This is the old house here, remodeling it, existing bedrooms, changing the layout a little bit. This is the new addition, kitchen, living room area. There's some elevations. This will be looking at it from the west, from the road, no, the lake side. No, this is the road. This would be looking at it from the road. This would be the lakeside area here. And just the side elevation. This would be the northeast side, and this would be the southeast side. This is the current existing site plan. 6 feet from the side property line. Here is the 16 by 16 addition that is in need of repair, needs to be removed and rebuilt. A wooden deck here, and the existing 12-foot lower deck down here. There's just the beacon map. The red area is the floodplain. It just kind of infringes on that area a little bit right in there. With the addition, it will infringe a little farther out there, so you'll have to get floodplain development permit completed and build the FEMA standards or prove that is out of the floodplain by a certified engineer. Just a beacon map of the location, the existing neighbor right here. And then it was a little snowy out there a little earlier. This is looking at it from the road. This is looking at it from the lake side, looking back up with the house, existing deck, the 16 by 16 addition. Looking on the southeast side, looking back towards the west, northwest. At the side, 6-foot property line. This is looking at from the corner of the deck, looking to the north. You can see it's in line with the other structures on there. It'll be, they'll be 4 foot wider out here, so it'll be right in line with the other structures up and down going towards the north. This is at the edge of the 20 feet where the proposed residential addition would be. And this is where the edge of the deck would be. Here, this is looking towards the south, and here I'm looking. I just turned around from where this wheel is right here. I turned around, looked to the southeast. You can see it's in line with the other structures along the southeast of the lake. This is looking at the lakeside, looking up, and this is just a summertime view of the cabin that the applicant had sent earlier. So just looking from the lake, looking in at the structure there. He did send letters to the adjoining landowners, and he did have one contact him back. Tori, the adjoining landowner, to the, get my computer to the, this adjoining landowner called and visited with him, and he had no objections to the variance request. So, and we've heard no other comments from the township or other adjoining landowners that were notified. So, and that's all that I have.
Okay, thank you, Richard. Mr. Squires, are you here? Would you please come forward and identify yourself and tell us anything that Richard left out?
Thank you. My name's David Squires. Richard covered everything pretty well there. I did send letters to all 3 property owners next to us because Mrs. DeBoer also owns the land that is on Tori's lot. Tori owns the structure. She owns the lot. So I sent all 3 of them letters and responses from Tori and also Miss DeBoer. Miss DeBoer was tickled to get a letter and thanked us for that. Tori his only concerns were equipment being on his property and our structure, not the deck, but our structure covering that window that you saw. It always feels like west to me, but it must be north or on the side of that window there that's on our cabin. So we're going to accommodate him, and he was fine with that. The structure will not be covering that. And he was fine with that. And Miss Anderson, she did not respond. I didn't expect her to, but I guess that would be everything.
Thank you. Questions from the board? We got a quiet group tonight. How about we'll open it up to the public? Do you have anything to say for or against?
I should introduce Carlisle Halverson. My wife Tara and I own the cabin with Carlisle Halverson, so Carlisle's here with me
Okay.
tonight. So I'm assuming he's for this.
I'm sure he is. Yeah. Okay. You don't have anything you want to say then? Okay. Okay. Very good. We'll close the public portion and go back to the board again. Kim, you have any questions?
Pretty straightforward.
Yeah, it is.
It
Okay.
appears that, you have to meet the requirements of the floodplain.
Correct.
That application has been applied for at this point, or?
I have been in communication with Jeff at Civil Design. He was reviewing things, and then he was going to get back to me and possibly had a few questions for Richard, but the process is starting.
So we could approve this upon approval of those requirements, those permit requirements?
Correct.
We don't have those in place, but that would be a condition of the variance would be that it contain those permits. And that's in our findings of fact.
We'll check and see. If I don't recall if I put those in there or not, but
Okay.
the elevations will come back. It's 6 to 8 feet above the normal high water mark, and if they're out of there, they do not need to be done. So as soon as he gets his elevations done to prove it, he does not need to meet the floodplain standards on there, as long as he has that certification from a certified surveyor saying that it is out of the floodplain.
Sounds good to me. I like the addition.
Mr.
I mean,
Chair,
you're lining it up with the other cabins and their decks, and I think that's appropriate. Since you are lining everything up, I think it's appropriate.
Mr. Chair, I've got Luke, over here.
Luke,
If
go
if
ahead.
you would, just one point along that lines, I took the time to take a look at, having done a review of for the pre-disaster mitigation plan, updated discovery maps of the floodplain throughout the county. It appears that the floodplain in the future, it is entirely likely will be shrinking laterally from the lake. Bottom line is what Richard just said and what he's saying are supported by the information that we see there. It's shrunk up considerably from what you see on that map earlier. So I just want to make that point that it is likely he's probably going to be out.
Thank you. Just I need to make a couple comments here. The board is very sensitive to what the neighbors have to say, and if someone's against it, that's usually can be a problem. But you've already covered your bases real well by contacting your neighbors. We like that. The next thing that it's too close to the lake, and we really have problems with being too close to the lake. But with your elevation, this is my opinion, not the board's, but with the elevation that you're at, and also being in line with your adjacent neighbors, I would probably look at supporting this. And I appreciate the work that Richard does. Richard does a good job taking pictures and helping us with this. So, other comments or questions from the board? Seeing none, we'll go through the findings.
Standard findings, and I'll read these through the application for variance, have them been filed with the Brookings County Zoning Commission. Acting as a Brookings County Board of Adjustment, a copy of the application being attached hereto. Such application being made by David Squires regarding the following real property. Lot 42 of DeBoer's Lake Tetonkaha West Subdivision and Government Lots 1, 4, 5, and 6 in the southwest 1/4 of Section 7, Township 111 North, Range 51 West, Oakwood Township. After due notice, a public hearing having been held on the application on the 2nd day of April 2019. Number 1, the Brookings County Board of Adjustment hereby finds that the strict application of the Brookings County zoning ordinance would produce undue hardship, that such hardship is shared generally with other properties in the same district and the same vicinity, and the authorization of such a variance will not be substantial detriment to the adjacent property, and the character of the district will not be changed by the granting of the variance. That the granting of the variance is based upon reasonable, demonstrable, and acceptable hardship as distinguished from variations for the purpose of convenience, profit, and caprice. The Brookings County Board of Adjustment further findings that the condition or situation of the property concerned or the intended use of the property is not so general or recurring in nature as to make reasonable, practical the formulation of a general regulation to be adopted as an amendment to the zoning ordinance. The Brookings County Board of Adjustment further finding that the written application of the petitioner demonstrates that special conditions and circumstances exist which are peculiar to the land, structure, or buildings in the same district, that literal interpretation of the provisions of the Brookings County zoning ordinance would deprive the applicant of rights commonly enjoyed by other properties in the same district under the terms of this ordinance, that the special conditions and circumstances do not result from the actions of the applicant, and that granting of the variance requested will not confer on the applicant any special privilege that is denied by the ordinance to other lands, structures, or buildings in the same district. Number 4, the Brookings County Board of Adjustment further finding that the reasons set forth in the application justify the granting of the variance, and that the variance is the minimum variance that will make possible the reasonable use of the land, building, or structure, that the granting of the variance will be in harmony with the general purpose and the intent of the Brookings County zoning ordinance, and will not be injurious to the neighborhood or otherwise detrimental to the public welfare. Number 5, the Brookings County Board of Adjustment further determines and conditions this variance on the following special conditions or safeguards. A, shape and size of DeBoer's addition, lot 42, 50 feet 6 inches by 137 feet. DeBoer's addition was platted in 1984 and replatted in 2003. B, location of existing cabin was built in 1974. C, lot was platted before the current zoning requirements. D, location of existing septic system, water, telephone, and electricity lines. The Brookings County Board of Adjustment, by at least 2/3 vote of its full membership, hereby grants the petitioner a variance for the above property described as follows. Build a 20-foot by 32-foot residential addition with a 16-foot by 36-foot attached deck, 24 feet from the highest known watermark and 6 feet from the southeast lot line. This variance is specifically conditioned upon initial and continued compliance with all the conditions and safeguards in 5 above, in compliance with all applicable provisions of the Brookings County zoning ordinance. If approved, the Brookings County zoning director is authorized to issue any required building permits for construction consistent with the terms of this variance. If this variance is not used within 3 years of the date granted, it shall be invalid. Dated the 2nd day of April, 2019.
Does the board have any questions or comments on the findings? Further questions or comments from the board? Anything? Go through the roll. Call the roll, Richard.
McHugh.
Aye.
Elankowicz.
Aye.
Erickson.
Aye.
Kleinjohn.
Aye.
Ford.
Aye.
Spence.
Aye.
Jensen.
Yes.
Bartley.
Aye.
And Rochelle.
Aye.
Motion passes.
Congratulations.
Thank you.
Thank you for your time. Next item on the agenda, board training with First District. Mr. Mueller, you're up.
Yes, I am. Yep.
That'll save us about 5-10 minutes of me trying to figure out how to run the computer. Always takes me back to my days in education. Learned how to be a teacher, handing out papers.
Gonna grade them too?
I never graded them. All right, since I am sitting here, and I'm assuming we're televised this time, I don't know that I've said my name today. I'm Luke Muller with First District Association of Local Governments, and I'm here to help you. Today, what I'm working on is I was asked to go through and since you had a light agenda and your staff didn't want to see you going home too early tonight, want to do a little bit of training, and I think what I've put together here, around a half an hour, and half an hour to 45 minutes, unless you want to go longer, and you'll kind of guide the last few minutes. What I handed you was a packet of what I'm going to go through. The PowerPoint itself, about the first half a dozen slides, go through this white sheet. It's just another way of showing this white sheet that I'm showing you here. That white sheet was drafted, put together by Zach Peterson and Jack Heeb, attorneys with Richardson Law Firm in Aberdeen. You're probably familiar with them. They've represented you before through the South Dakota Public Assurance Alliance as anytime you've found yourself in court on some cases. And they put this together, presented at the South Dakota Planners Conference back in October. And their plan was to present the same information at the South Dakota County Commissioners Workshop in March, prior to Snowmageddon in the middle of March. So that got canceled, and so now I'm winging it with their permission, trying to sound as similar to them as I can. So that's what it is. If you hit F5, that'll probably show up.
F5, okay.
Yeah, there you go. Maybe. Ooh, hello. Or it'll go away.
Where'd we go?
There we go. All right, so first thing, I introduced myself. I am a planner, senior planner at First District Association of Governments. We hired Tom, so I get to be the senior planner now. The main thing you see on there, a couple of jobs I have. One of them is not an attorney. I'm not an attorney. This is not a legal opinion. I do talk to a lot of them. I do my best to try to relay what I'm told from the attorneys, and that's a lot of what you're going to see here is just regurgitating a lot of what we've seen there, but it's some information you don't typically get exposed to, and that's really what I'm going with. So if you'd go to the next slide, I'm going to point out that I am human, and this was a copy-paste, and that slide has nothing to do with what we're talking about. Let's go to the next slide. There we go. What we're actually going to talk about today, is that was a head fake on the second slide. Three things, basically. Conflicts of interest and ex parte contact in the form of proceedings that you handle, which is quasi-judicial. I talk about a couple of recent court cases that I'm sure you're happy haven't been including you. They're in some other counties that have been in this circuit, though. And so I just kind of wanted to update them. They kind of fell in my lap as far as decisions in the last 30 days, in all honesty, and I thought it'd probably be worth mentioning how they've gone. And then the last part, if there's any topics you want to talk about specifically, I'll just kind of talk about a few things that are hot buttons around the state right now. If you want to lob some thoughts at me, you can. Otherwise, if you've got questions, you can, or we can just run. I'm going to go to the next slide, Richard. So going off of this sheet that you've got in front of you here, you can go bounce back and forth as you please. A lot of time was spent and a lot of questions. I get a lot of questions, and I know a lot of court cases have gone back and forth questioning just what are the roles of you as a board member when you're sitting at this, especially since you're wearing two hats. You're the planning commission as well as the board of adjustment, and how do I handle them? How are they different? Here's the bottom line. When you're sitting as a planning commissioner, you're a legislator. You're making a recommendation, but you're a legislator for all practical purposes. You're not making the final decision as a planning commission member for a plat, for a rezoning, for a comprehensive land use plan. The buck doesn't stop with you. It goes to the next entity. On a board of adjustment item, such as a conditional use permit or a variance, or if someone disagrees with what Richard or Bob say, you are the last line of defense. You are the quasi-judicial entity. And so those two are handled differently as far as how you can be involved in your forms of conflict, for that matter, and what is and what isn't a conflict. So, as I pointed out, you point out quasi-judicial, ultimately you're making the final decision. You're making the decision on how a specific property can be used in a specific case. Obvious, you know that. Legislative proceedings, though, are different in that you're not making the specific decision on them. You're really just saying this is what the rule ought to be. If at some point we have someone come in, this is how we ought to, in general, be handling it. Bottom line is that you're not, if you've got an opinion on a topic, it would be totally relevant within a legislative proceeding as opposed to the quasi-judicial matter. On the quasi-judicial matter, you're looking at enforcing the book. Legislative matter, you're using what you know. So, and that's a lot of what he's got in number one there. In number two, I'm not going to, I will, but I'm going to summarize as much as possible. The types of conflict of interest. I know Todd Kays came, the director at our office came, talked a little bit about conflicts of interest and findings of fact in previous, I know I've talked about it in previous trainings as well. There are four types of conflicts of interest that have been defined. They went through, the court case was Hanig versus the city of Winter in a liquor license case, but that was essentially the case law that established what is and what isn't a conflict of interest. And there have been statutes built after that, as well as that adopted after that, as well as some court cases to clean that up a little bit. But the bottom line is there's direct pecuniary interest, which is I hand Terrell money. Okay? There's indirect pecuniary interest where I hand someone money that is associated with Roger, someone who's close to him that may be able to convince him that, hey, maybe you ought to vote for this one. There's a direct personal interest in which it's you directly. And that seems pretty obvious. You probably shouldn't be voting if you're the applicant. There's the indirect personal interest, which winds up being a little bit, it's trickier to define. And that winds up being, be it relatives or be it family or be it a club or organization you're a part of in some cases that would directly benefit. And generally there are, the ones that I've seen, there haven't been a lot of, that hasn't really been a huge basis for them unless you can prove that they not only have this link, but they've also furthered their cause or their intent. They've made it clear in some way, shape, or form that that they've done their best to try and push that agenda, whatever that agenda is, in that decision. Like I said, the full definition is in here. It's important to know that, but I'm really glad that Zach and Jack took the time to list those out. My suggestion to you is keep them handy. If you're not sure if you fall into one of those on an item, you want to check with your attorney and just see how they feel, if they feel like you are. If you go to the next slide, please. The next part becomes where it's more difficult. How are you going to determine whether or not you've got a conflict of interest? And basically, as I said before, be aware of what types there are, first of all. which is where that part comes in. But probably the main thing, a couple of the main things, you're going to see me say this a couple times today, is make the potential conflicts known to the board. I'm going to reference that in a court case that we saw in this circuit not too long, but if there's a potential conflict, make that known. Disclose, disclose, disclose. You're better off making the point that my third cousin's uncle signed up for, I don't know, a gravel pit permit, and it's not going to affect my decision, but I felt like it was relevant to point that out. At that point, you've stated it, does two things. One, it puts the public on notice, the applicant on notice as well. One, maybe it's something the applicant doesn't like. Well, they can stand up and object to you standing up there. Ultimately, the decision, though, rests on the board. It's not up to the public as to whether or not you're voting on it. It may be up to a judge in the future, but it's ultimately up to the board. If you feel like you can still vote even though there's this peripheral thing that might be involved, say it. There's nothing wrong with that. We had an individual in Kynan County that his sister signed up for had a wind easement. Lady got up and said, no, I object to him voting on it because he's got a wind easement. Or his sister's got a wind easement. He said, I don't get any money. I'd be happy to not sit in here if you don't want me to, but I really, it's not going to affect me. And the chair said, well, you don't get out of it that easy. You got to stay here for 4 hours. So the bottom line is that it's a case of, it's ultimately up to the board as to whether or not that's a problem if they disagree with you. But at least you disclose it and give them the chance, as well as the public. Same thing, opposition or for it.
I think, Luke, you want to tell them that actually the chair doesn't make the decision necessarily. It can be voted on by the...
Exactly. Generally, and there are a couple of ways you can go about doing that. I suggest having that manner within your bylaws specifically, but generally speaking, if someone states I don't feel as though I've got a conflict of interest, ultimately it starts with the chair. The chair can make that decision, but there is a procedure for appealing that decision. There's always a procedure for appealing the decision of the chair. And so the bottom line is, if someone says, if Bob as a chair would say, I agree with you, you don't have a conflict, and someone else says, well, I totally disagree with that, appeal the decision of the chair and there's a forum to do it, but in the end it says, I appeal the decision of the chair. I think Bartley should not be seated on this. There's a second, you vote on whether or not.
The chair can often say, without objection, I don't feel that they have a conflict. That tells people that if you have an objection, state.
Exactly.
So without objection, I'd say they don't have a conflict.
Yeah, so there's always that way. It starts with the chair. It can go to the full group. And that's the handiest way, is like you said, without objection. This is how I see it, board. Anyone disagree? So, and if you do, the other thing that I tell you, and I know I've told you this before as well as a board chair as well, don't be afraid to vote on something that you're not sure of. Be it a finding that you feel like is dividing the board, or a case like that where, clearly two people think it's a big deal. Well, let's just vote and be done with it. Make sure. And that's what that would be. That goes to the next point that I had in there. That's establishing the manner and how you're going to do it. Does it have to be written? No, not necessarily, but it sure does help in that. And but what if someone did vote that had a conflict of interest? What happens? Well, that's what you see in letter D in 6117 on this sheet. If an official with a direct pecuniary interest participates in discussion or votes on a matter before the governing body, the legal sole remedy is to invalidate the official's vote. So that vote doesn't count, is what it amounts to. Now, we'll see where that became a problem, but you know as well as I do, a variance requires a 2/3 vote of the full membership, requires 7 votes. Your vote is disqualified, that's essentially a no vote at that point. Period. Whether you meant yes or no, it's a no vote. On a conditional use permit, now your ordinance is a little bit different, but with state law says that it's a 2/3 majority of the members present and voting. In those cases where you've got a present and voting standard, well, then that voter just falls away and you don't count that person, period. And so it's a 2/3. You'd need a legal opinion on whether or not your ordinance is able to, or whether or not you can still require 7 votes on a conditional use permit, or whether or not that state law applies in which it's 2/3 of the members present and voting. I'm not going to step on that landmine, but the bottom line is that it's a little bit of a different animal between conditional uses and variances. But the bottom line is, again, it's not overturning the decision. You know, we've seen that enough now where people say, well, someone voted that shouldn't have, and you should just say no then. Just overturn the whole stinking thing because they screwed up. And the judges said, no, it says right here, we just disqualify that vote. That was Kelly in Minnehaha County. That was Armstrong. Actually, Armstrong they did, but that was because he did a lot more than just vote. And then in Dual County, it was the same way. And we've seen that in other counties as well. The other point that I want to make is in number 4 that they have in there, which is, it's not just if you feel like you've got the conflict of interest, you need to give that wide berth, is what I'm going to say. Disclose anything that may potentially be perceived as a conflict of interest. And so allow the lodging of objections, but decision ultimately rests with the board. The point is that if there's a potential that someone may perceive you as having a conflict of interest, you're better off describing the narrative than leaving it up to someone to imagine what the problem is. And so imagining why you didn't say it. And so, because what I've seen a lot of times is where that winds up being written in a discovery document instead, is that, well, they did this and here's why and this and that. You're better off stating it at the meeting and just putting it on the record and being done with it. The other thing is that you need to keep in mind and this comes up in the Dual County case, but through any of these conflict of interest cases, it's not necessarily a case of direct conflict, but if there is and I forget I've got the term in there, but if there's a perception that a conflict could take place, then you're in violation as well, is what it amounts to. Your individual vote may not count. It's a perceived conflict is what is probably is as important. So I'll get into that in a minute because right now.
Yeah, the other thing, Luke, on that is if a board member feels that another board member may have a perceived conflict, it's appropriate to state that and have it adjudicated, so to speak, from the board, whether they agree that other board member has a conflict. So
Right.
even if I don't disclose it, but you know I have a conflict, and you go, he's really got a conflict. He really, we really should talk about that. Go ahead and state that conflict that you believe is necessary and let the board decide whether, I agree that board member has a conflict. Because sometimes you'll get a board member that won't declare a conflict because they really want to vote on it, or they really don't think they have one. So it's appropriate for the board members to, basically police yourselves in some regards.
And the other point to that is that I'll go back to, you're better off having that discussion here than in front of the judge. So, because that one point may wind up being moot. Hey, don't you work at Egg? Don't you work at Egg first? Doesn't this person come in all the time? Yeah, but so does everyone else we see, and that might be it, but at least you've aired it, given that opportunity there. So that's the sort of thing that really goes, at least you have the chance to talk about it and point out why you allowed that person to vote, because that at least puts that on the record as well. And so that you can point out, that was ultimately in the case I'll talk about with Kynan County, that's ultimately what the judge said, is that one, there wasn't a conflict, and two, the board said why. So that was ultimately the end there. Any questions so far on conflict of interest? Because I'm going to go to ex parte communications here, talking outside of a meeting about something.
So if they're found to have a conflict, it's a moot vote.
Your vote doesn't count if you're found
Right.
to have a conflict of interest.
So then if it's like a tie or something,
Then that would
Whole different
ultimately
ballgame.
lead to the flip of the decision. Yeah. Yep. Which is dual county.
Well, I'm not sure on this particular board if we can take if somebody's recused themselves or is removed from voting, can we take an alternate to the table at
Yes.
that time? So I think that's important to know too, that you can take an alternate to the table to get you either your quorum or perceived quorum.
In
And
this
I don't know
county,
how our regulation reads, whether it's members present or total quorum.
I believe it's members present.
Okay.
But I would have to look to be sure.
yeah.
You wouldn't necessarily have to have an alternate come up, but it'd be appropriate to do it anyway.
This county, you do a good job of, your alternates do a good job of
They show
attending
up.
meetings regardless. I go to a lot of places that they just don't show up if they're not
Don't
needed.
show up.
And sometimes if they are needed, they don't show up. But that's one of the benefits. The other thing that I would point out is that you've got that item on your agenda ahead of establishing the agenda. That's the point to do it, so you can point out, okay, for item number 7, my cousin's brother's uncle knows this person. I think I'll be able to vote. Have that discussion at that point so that the public's on notice that this person may or may not be coming up to sit in my seat, as opposed to trying to catch it before the motion, because every now and then, worst case scenario is that because you're doing it right, you run Robert's rules correctly where you ask for a motion before you do anything. Well, out of habit, sometimes, I know out of habit, you'll say motion, second, oh crap, I was supposed to recuse myself. Then you get up and then you make that statement. Well, then we've horsed around the process. That's what happened in Minnehaha County, only he never did figure out he was supposed to recuse himself. But that's why that thing got a little bit jacked around. But I'll go on to ex parte communication. If you just flip the slide here. An ex parte communication is a communication between a decision maker. I don't have to read this to you, but it's a decision between interested parties outside the official channels of a proceeding. This is where, again, operating as the Board of Adjustment, you think of yourself as a judge. You're 9 judges sitting up here. And imagine if you found yourself in a situation where you had to be in front of a judge because you got pulled over and you found that arresting officer. You went out the week after or the week before your hearing and you found the arresting officer out having a steak with the judge. They could be talking about anything. But what are they going to be talking about in your mind? They're probably going to be talking about that item. So again, that is essentially the opportunity to have that. Now, there's some difference in there that I'll go down to on number 3 here, but what if ex parte communication occurs? Again, say it at that point. Has anyone had any ex parte communication about this early on in that, before you set your agenda? Point it out. I was at the basketball game. John came up and told me he has an application before us. I told him to show up to the meeting and tell us everything. Do you have to say it that way? No, you probably don't. But you know what? You never know who's in the audience and who saw you talking to John. And that's why you want to point that out. Yeah, all it was you were both holding a cup of coffee and happened to be in line together. On the other hand, you might be at your pinochle party and you might have been teamed up with John, and 4 hours later you might have the whole thing figured out. Well, then you probably better recuse yourself because you went a little bit too far. But and if you do it once, I think they'll let you stay on the board. You do it every week, you might have yourself some time not having to be on the board anymore. But so again, it's knowing that line. Now, does it always require a recusal? No. And this is where it's relevant, especially because I've caught a lot of been to a lot of meetings of late in which the public definitely does not understand this. And I can't blame them because most board members don't understand this. And this was ultimately, this very last bullet point here was what Zach and Jack really wanted to talk about at the planners conference, and this is what spurred it. The legislative versus quasi-judicial function of you. Again, you're acting legislatively when you're adopting rules and plats and drafting land use plans and ordinances. The fact of the matter is you're human, and you're encouraged to be human when you're on the planning commission. When you're making recommendations, you're allowed to have your own personal thoughts. You're also allowed to have conversations with folks outside about it. I mean, the bottom line, you see the question. I've seen people, they need to recuse themselves because they have a feedlot, so they shouldn't be writing rules on feedlots. Well, on the other hand, maybe they should be because they know more about them in some cases. But the main thing is, would a legislator recuse himself if they got a phone call from a constituent? No. That's their job. That's essentially what your job is. Somebody calls you on a topic that you're making a recommendation for a new ordinance or a rezoning. Makes sense. Do legislators recuse themselves when there's a bill that could directly affect their pocketbook? No, they don't, because that's their job. And you can't argue that an increase or a decrease in taxes doesn't affect them. They don't have a pecuniary interest. When you think about it in that aspect, obviously you're going to be voting on things that could be affecting you in the future. But you know what they don't do? They don't affect you immediately. They're not only affecting your property. That's where it goes back to that quasi-judicial point, is that you are acting directly on this one decision that's going to affect this one property. And that's where that line, you've got to figure out whether you've crossed that. And you, thankfully, are not in that alone. You've got staff, you've got your state's attorney, and now we've just convinced you you've got 8 other board members that can tell you if you crossed the line while you're sitting up there. So the problem is it's live and in Technicolor. So, but the one thing that we have run into in a court case, and it was Berg versus Grant County. Again, really fortunate because in our area we tend to write a lot of case law in South Dakota. Grant County, no exception. They've been to Supreme Court quite a bit lately. And one of the questions that came up was, had an individual came up to all of the board members on a specific feedlot, and she made them cinnamon rolls and went and sat down and had coffee with them at their house. And ultimately, and there was, I don't believe it was all of them. I think it was over half, though. And in the end, the decision came down from the Supreme Court that was an uninvited discussion. The board member didn't go out and seek that information. And so they did draw a line between invited ex parte communication versus uninvited ex parte communication. Now, there's also a line in there where you need to probably stop that, and that was never explored. But the bottom line was, in that case, the point was made by the applicant who was denied the application that, listen, this lady came and lobbied these people. Well, what do you do when your neighbor shows up with cinnamon rolls? Do you slam the door in their face, or do you accept them and just mow them down? Well, yeah, you mow them down, of course. So that's ultimately what some of them did, and they talked to her and gave her time. So that's ultimately what it was. But that line, it's an important indication. I'm not going to get into what that is because that's where I think the legal interpretation comes into, but there is a difference between whether or not you went out and sought that conversation or it came to you. And so, again, that's where I made that point about being at the high school basketball game versus going to the place you know that Joe goes every Tuesday morning to talk to him. So that concludes this sheet here. And that is something that I'm betting we'll probably be going over again, or I'm betting Zach and Jack will probably be talking about again in October in Pier at our, when we have a redo of what we had intended on doing of the county commissioners and planning commissioners being able to go out there. As well as they'll probably add something else to it because I'm sure we'll have more case law to talk about. But that was that portion. And then any questions or any instances you want to talk about with regards to ex parte communication with you, if you've got any questions before I move on? Well, fun. Well, this has been fun for me to talk. Let's move on to the next slide, if you would, Richard. So, for some reason, and I'm not sure how to introduce this, but I was here a month ago, and you had two individuals here, and there was only the applicants with regards to the laydown yard for the wind farm that'll start construction here relatively soon in your county. I am fairly confident in most other counties that I work in, we'd have had a full room. I don't know what the difference is, why it's different, but it has been. And the bottom line is I've got, I believe, 5 court cases either just decided or being worked on right now in court involving wind farms within our 11 counties that we work in. And 2 of them were recently decided, and I thought, what better time to tell you about what we found out in the circuit court decisions than now. And so, again, these are circuit court decisions. They are not settled in the Supreme Court. This decision in Dual County, I think the window has passed to be appealed to the Supreme Court. I don't think it's going to be. I frankly don't know why it would be, because frankly, nobody won, is what it amounts to. Everyone kind of lost. And the one in Kynan County could still be appealed, but at this point, it's hard to tell. I think they'll probably roll the dice. But the Dual County court case involved a wind farm, and it involved a lot of conflict of interest question. And the judge in that case is from Watertown. She's a former state's attorney in Watertown. She ultimately ruled. She upheld the decision of the board, didn't overturn. Maybe the better way to say it, she didn't overturn the decision of the board. However, I'll get into that in a minute. A number of accusations were levied against board members, staff members, what have you, with regards to that case. And ultimately what I had in here, and I really summarized these in 2 slides, but she relied heavily on Armstrong versus Turner County. And Armstrong versus Turner County, I've told you about before, but it was a case where a zoning officer issued a permit for something that required a conditional use permit, went, oh, time out, I screwed up. And ultimately what happened was, no, the neighbors said, time out, you screwed up. Went on appeal to the board, said you needed a conditional use permit. The board said, yep, you're right, we did, despite the fact that this elevator has now dropped a little over $2 million into this project after the zoning officer issued the permit. Required the applicant to come in, get a conditional use permit, and after about 3 months of negotiations between one board member and the applicant, as well and the public sitting in the same room, in which in the meetings the board member pointed out that he was just trying to save a lawsuit, trying not to get the county sued. He then at the meeting helped to present the case for the applicant and pointed out, made the motion to approve as well as all the findings. And so the judge said, you pointed out that you're trying to save the county from a lawsuit, not trying to decide whether or not the rules are being levied fairly. That's the first problem. And secondly, you thrust yourself into a position where you ran the show. And so that was the only time I've seen a case in the last 10 years that I've been doing this, that it just got flat overturned on the east side of the state on something like that in that case. On the west side, I've seen some cases over there get turned over on findings, but bottom line, that's how it was. Dual County tried to argue that The only thing that really needed to apply, if you remember, I went back to SDCL 6117 on what Zach and Jack had put together. Portions of that law a lot of that was written in response to the Hanig case in Winter that I mentioned. And in Dual County case, we tried to argue and specify that was written in an attempt to specify what was meant by a direct pecuniary interest and specify that that's really the only conflict of interest. Judge Elsher didn't buy that, is what it amounted to. Not entirely, though she did reference it. She did point out that the unacceptable risk of bias is what's relevant. And so that's what I was stumbling over that phrase, is that there's a level of unacceptable risk of bias, and that's what the judge is ultimately deciding. So I put on two sides here. She disqualified the votes of 2 board members who were signed up for easements with the wind company, however, had gotten out of their easements. However, they had received checks in the past from the wind company. Seems pretty obvious now. They probably shouldn't have voted. But at that point, it didn't seem obvious to them that they shouldn't have voted. So they voted. And Judge Elsher said no, that they shouldn't have voted. The fact that they no longer receive payment really isn't relevant. They did receive payment from this person for this direct purpose of what they're making the application for. So that's unacceptable. Now, she upheld the votes of individuals that had complaints like I've got on the other side levied. One of them, their employer has wind easements and receives payments, however, he does not. One of the individuals had a transmission line agreement with a different wind company. They argued that, well, see, he loves wind power because he has a easement with a different wind company. That'd be akin to he always votes for feedlots because he's got a feedlot. It would be similar to that argument. That individual did note he's generally in support of wind power during the planning commission hearings when they were updating their zoning ordinance. And that was something that the judge said that's perfectly reasonable that someone's going to have a personal opinion. There's nothing that indicated that he tried to further that specifically within this. And then there was one that had this was a stretch, but he was a minority owner in a company that sells stuff that might go into wind towers. And the judge said, well, that's really speculative. So again, upheld the votes of board members in that case. What I took from this is that if you've got a check in your hand for any reason from the applicant, if you can be proven that you've gotten a check from the applicant at any point for something that may be related to what's being asked for, you better not vote, regardless of whether it was a week ago or several years ago. You probably better be checking with your attorney as to whether or not you should be voting. Chances are probably no, is what it amounts to. That was what we got directly out of that case. And I'll go to the next slide here. I think there's one more point in here. I should point out this application was for a wind farm in Dual County. It was approved by the board. I don't recall how many wind towers. I'd have to go back and look. But a couple of things that were in here. The first bullet point's already been decided in other cases, but it pointed out that prescribing an orderly procedure for time limits does not deprive individuals of due process as long as you are consistent and you state it ahead of the meeting and you don't just all of a sudden go, okay, no, now we're done taking 5 minutes, we're just going to take 3. So it doesn't deprive due process. That's been argued before. The board performing its duties in past cases does not create bias. This was a fun one. An individual had applied for an airport permit about 6 months before this application was made for a wind farm. Some think that it was in order to try and keep wind towers away from his house. Either way, what the board did is they approved his permit for an airport, but acknowledged the fact that neighbors had wind easements and said, you're going to have to sign a waiver of right to protest if they put a wind tower at the edge of your runway because they had this first. The argument was, well, they displayed that they are biased toward wind towers because they honored the wind towers agreement ahead of ours, or the wind easement ahead of ours. And bottom line is what the judge essentially said is that they made a perfectly rational finding in that case. In either way, we're not reviewing that case. We're reviewing the case at hand now. So frankly, I'm really not supposed to be looking behind the curtain anyway on that case. It really makes me think of but that part really reminds me of the skit by one of the, not Larry the Cable Guy, but Ron White points out that they got pulled over once, but it was entrapment because they were pulling over everybody that drove on the sidewalk. You can't blame the board for making the right decision, doing things the right way every time they do it. And so if you didn't question them the first time, don't question them the 10th time. Next point, failure to read and review every piece of written material submitted does not indicate that you were biased. It may indicate you probably should have looked at something, but in this case, the opposition dropped off 518 pages of documents the day of at the hearing, then pointed out that they didn't reference all 518 pages, and therefore they must be biased because they ignored what we said. That's not what the judge said. They did have discussion about things that were brought up in the hearing. I don't want to make it sound like they didn't. But there were points in there that the 518 pages, they clearly did not read them at the hearing. That does bring me to a point. I'm going to step out of that and point out that if you do not have a rule or a cutoff on when you take written materials, I'd really suggest you think about it. And then it only becomes oral materials presented at that point, putting that into your bylaws, because you know as well as I do that that could happen to you at any given time as well. That argument be levied against you as well, that someone brings a 200-page report the day of the meeting and says, you better look at this before you make a decision. That can't be anything but trying to slow down a process when you're handing it to the board that at the meeting, because the applicant doesn't have a chance to look at it in that standpoint, or vice versa. If the applicant says, you know what, I changed my mind, here's 200 extra pages of engineering, we're going to do it this way, that's akin to doing the same thing. So, and just something to think about. You may want to think about that in your bylaws, to have a cutoff and when you take written testimony. Not saying you don't take testimony, but as to when you would take written testimony. The last point that they brought up was there was an irregular process in that they voted on meeting one. They came back, they had their staff prepare findings, and they brought them back and voted on the findings at meeting two, and then said the permit wasn't effective until they signed the letter of assurance agreeing to the conditions. I know you don't do letters of assurance here, but you do tie conditions to things in some cases. So you may have an agreement on certain conditions, but the point was that it's perfectly acceptable to take your time, write your findings, say that they've got time to think about whether or not they want to sign it before they agree to having the permit in place. Here's the thing that Dual County ran into, though. We've had discussions over the past, in my time, 10 years, that they need to update their ordinance to get the phrase special exceptions out of their ordinance and use conditional uses. They haven't done that. And so everything's listed as a special exception. Conditional uses require a majority of 2/3 of the members present and voting. Any other decision of the Board of Adjustment requires a two-thirds majority of the full membership of the board. Since it was not a conditional use and it was a special exception, 2 of the votes that were for yes were disqualified. Therefore, they no longer had enough votes to uphold it because they did not have alternates and it was not a conditional use, it was a special exception. So the net effect of the judge's decision was that the decision got overturned, despite the fact that she upheld how the board acted throughout there, except for those 2 members. So moral is, Luke is going to Dual County to be involved in that public hearing in a month as they reapply on that to rehear it. So that's where that one wound up. Are there any questions? Have you heard any hearsay about that? Any myths or anything that you think doesn't add up with that one? Like I said, it seems pretty obvious us sitting here now, but Don't have a date set yet. I have been told they're going to make application, and I've told them we'll pick a day when you make application. So at this point, I expect it probably to be the first week of May, but I don't know that for sure. And that window's closing on the first week of May. Well, let's move on to the Kynan County case that I was involved in. I know a lot more about that one. I just got 2 more slides on this, and then I can be done and let you drive this a little more too. The decision on that was a different judge, same circuit, also from Watertown, that judge is. And he really relied heavily on, as we see in a lot of circuit court decisions, you'll see in them, and I know in some cases you've had, they'll point out, first of all, that it needs to be a de novo hearing and as opposed to a writ of certiorari. 2 terms, de novo hearing, I'm going to simplify and mean it's essentially a rehearing in the case. You bring forth all the arguments, the judge essentially becomes the final say on a de novo. And a writ of certiorari, I'm really going to simplify this. But basically, the judge is reviewing whether or not you followed your rules. There's more to it than that, but the bottom line is they're basically checking whether or not you followed your rules. In that case, specifically, it's not a rehearing of the facts. In those cases, it is a rehearing of whether or not you followed your steps of your ordinance. Were you a biased decision-making body? Did you provide notice? Was your decision arbitrary and capricious? Did you say yes to this person in the audience, but no to this one? Those sorts of things. Did you hold a public hearing? Again, this is not a rehearing of the facts in the court case. It's not a rehearing of what the applicant thinks the board got wrong, or what the petitioner thinks the board got wrong, which is what judge stated. Made it look as though some of the things were. The other point that he made is that if an argument, and I'm summarizing here, and I will point out I took a little more liberty summarizing this because I was involved in this when I remember it a little bit more, and also bounce these ideas off of our attorney to see if I was on the right track. The point was, if arguments weren't made at the board hearing, they're not relevant in the case. You can't argue that the board didn't consider this when you didn't tell the board that was a problem, is what went on. If you thought that was a problem, you should have brought that to the board. They're the ones making the decision, not me as a judge, is kind of what it comes down to. The other thing that came in, and I'm taking these as bullet points. Judge gives credence to bylaws. Adopt them and follow them. I know you've got bylaws. Frankly, you are the lead in this county. This county has had bylaws for many years. Only recently have a lot of the other counties come along board and done so. And honestly, I don't know why we haven't in the past. Just to say, here's how we do this and that. And if you find something that you're not sure how to handle in the future, or maybe you want to remember, hey, that worked really well, write it down and adopt it and put it in so that anyone can see it. Here's how we do things. And then the other thing is follow them. Make sure you follow them. You don't deviate from them. And if you do, you better have a good reason as to why you do. But in that, there were multiple references to the bylaws, that the board followed them clearly. And you can't argue that, because in Cottington County, their bylaws say the applicant will be given 10 minutes, if I remember right, to state their point. And then once the public hearing is opened, anyone in the audience, anyone wishing to speak has 3 minutes to address the board. And then once everyone has addressed the board, then the public hearing will be closed and the applicant comes back up and the board asks the questions that were asked of the applicant during that, as well as any board discussion at that point. And it was argued that that's unfair, because I think it was arguing that that the county was exercising bias in favor of the applicant, as well as just being unfair as to no rebuttal. Well, 2 things. 1, this is not a civil proceeding. You're not bound by civil proceeding rules as a board. And 2, you're allowed to make your own rules. In fact, the judge said it's perfectly reasonable to make what your rules are going to be, as long as you don't change the ball game on people. The other point that's in there is disclosure of potential conflicts of interest is good, is what came out of there. It's not exactly what he said, but basically the point is that it gave the judge more to consider. He referenced the discussion in the testimony. He referenced what he heard in that meeting, that the individual spoke out, the person on the board spoke up, said what the deal was. He heard that an individual in the audience didn't like it. He also heard that the board's reason as to why they thought it made sense for him to vote. If that had not gone on, as I said in that next one, don't let the petitioner speculate why you didn't bring it up. You're better off hitting that off at the pass instead of letting them write the narrative on it in a discovery document or having to defend it. Just flat out say whether you are or aren't, or if you're going to vote, but there might be, just say why you are. And the worst case scenario is that you get to go sit in the other room and drink coffee during the hearing. So that was how that came in. The other point is, and this board does a good job of that, be thorough in your hearing and your review. There was one instance in that discussion in which there was something within the application that was not clear. And in fact, there was one portion of the application that indicated a tower was here, and there was another part that indicated it was somewhere else. However, during the hearing, the board asked, what about the towers here? Do they all meet all of our rules? They were specific about the portions of the ordinance, asking, are they going to meet this? Do you understand if they don't meet this rule, the tower's coming down? Yes, sir, yes, sir, yes, sir. And so the bottom line was that because they had an hour and a half of discussion. I don't know that you got to have an hour and a half of discussion, but because they thoroughly vetted and they reviewed whether or not it met the terms of the ordinance, they were able to point out that despite the fact that this one detail was different here versus there, they clearly did not just say, well, we don't really even need this application, you're good. They asked the questions. They followed through. Make sure you do that. Continue doing what you do. That's really what I'm saying to you. Make sure you're asking questions of the applicant. Make sure you're asking questions that relate to the testimony that was brought up, especially if it's relevant. In some cases, even if it's not. But I mean, make sure you're asking the questions. Just because a question was brought up doesn't mean it's germane to the ordinance, and it doesn't mean that if they say no or it doesn't meet the answer that makes the audience happy, it doesn't mean it necessarily is wrong by the ordinance. But it is worth asking the question of them. You don't want to ignore the questions of the audience. And then participate. Everybody participate if you can in the discussion. Next slide, please, and I'll finish. The last point is one that I've heard many times, and I'm sure you've heard brought up a time or two in your time on the board. Many of you have been on the board for quite some time now. Have the purpose and intent statements recited to us in our testimony against an application. And I've heard this many times, and I'm paraphrasing largely from attorneys that I've talked to that have told me that the purpose and intent of the ordinance statements, and there are usually 9 or 10 statements in there that indicate what the purpose is, but this that steps back to that's in quotes in that document there on the whiteboard there, to protect and to promote the public health, safety, peace, comfort, convenience, prosperity, and general welfare. Your ordinance has that. Pretty much every zoning ordinance has some version of that. Why? Because state law has some version of that as well. And what we hear in many testimonies is, I think this should be denied for this reason, specifically because your ordinance says that it is written to protect and to promote the public health, safety, welfare, peace, comfort, convenience, prosperity, and that doesn't do that for me. And what the judge in this case said, contrary to the petitioner's assertions, these objectives are clearly not elements or factors the board must expressly find in every and any conditional use permit for a wind energy system project. Moreover, the record reflects that the board considered information about tower placement and determined that such placement complied with the ordinance. That only supports what I've heard out of other attorneys, in that statement goes toward what follows should be for the public health, safety, welfare, peace, comfort. Each individual decision isn't going to be in the best interest of one person at a time. It's in the best interest of the county. And in some cases, yes, some neighbors are not going to like what the answer is. For example, I just want to go to a variance. If you got a variance and there's a cliff on the backside of a lot, and it forces you, it forces the only way that this individual can build a house is 4 feet from the property line, and that person on the other side says, no, 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 I don't want them to. Well, guess what? They do have a hardship on their property. Might I have a shadow on my property now because that house is going to be 4 feet from the south edge of my property? Yeah, you might, but you know what? There is a definite hardship here. You're right. That does not directly help your property. It's not going to help the health of your property, but it is, from the standpoint of your ordinance, it does have a hardship, a definite hardship in that. And that goes back to a variance. I'd like to pivot away from conditional uses and think of it from that standpoint. But bottom line is that when those come up, at least that appears to support that statement. Now, I'm not going to say that is universally upheld or universally held by all attorneys in the state of South Dakota. I don't even know as far as judges, because I haven't seen that question argued in front of the Supreme Court. But that is consistent with what I've heard out of other states' attorneys. So, I'm off of that case. Any questions on that one? Either of the court cases I brought up? Anything you want to be watching out there? Okay. I had 3 slides at the end. I'm just going to point out what they were on them. There's really only one that I want to mention something about, and it's something that you really need to keep in mind. And there's some things, hot topics in zoning we've got. I mentioned moratoriums and the fact that there is no reference to moratoriums in zoning laws in the state of South Dakota. Wind energy systems are a big hot button issue. If you'll go to the next slide. Feedlots, of course. We can talk about policy trends. If you got questions on what other places are doing on wind towers and that, you certainly can. What we're seeing is more and more permitted special uses and variance standards. And there's a reason for that. A good argument was made in Yankton County several months ago with regard to a variance having been granted on a feedlot to a section in the performance standards of a feedlot. And the argument was made that a variance is a term indicating hardship. That it references what the definition of a variance is, the hardship that needs to go on there. The argument was made that when you're granting a variance to requiring a state general permit, well, what's the hardship in getting that state general permit? That's not a great example because you better get a state general permit. But if you're granting a variance to a performance standard, you need to plant 6 rows of trees. Well, this time you can plant 5, you'll be okay. Why? Why can't you grant 5? What's the hardship here? You own a quarter section of land. Why can't you do it? The point is, what we're seeing in more ordinances, that discretion, if you've got a performance standard in your ordinance, they need to meet that. If you think there's an instance where you would be okay with them not meeting that, you need to write it in your ordinance that it's okay. For example, the sign off of a neighbor on things, which makes perfect sense. It does. But you need to have that in the ordinance to allow them. So you get those, I call them get out of jail free cards. Write those get out of jail free cards in the ordinance. Now, don't get me wrong. If you got a history of granting variances, 10 times out of 10, when this variance comes in, we grant it. If they've done X, Y, and Z. Yeah, you've probably got a better case for that. But if someone can pull out one instance where you said no in that case and everyone had that, it makes it pretty tough. And honestly, they're probably right if that's the case. So just kind of keep that in mind. If you've got those, be watching that within your ordinance as you're doing things. I'm telling that to everybody. If you've got these get out of jail free cards that you grant a variance every time someone does these 3-4 things, don't make it a variance anymore. Make it allowed if they do these things. That's my suggestion. Any other topics you want to know about anyone else doing?
Just a point on those letters from the neighbors in
Yeah.
support of your variance request. Make sure they're written and permitted. I can come in, my neighbors don't agree. It happened tonight. I sent out a letter to everybody, but there's no correspondence back other than verbal correspondence. And if you really needed that, you need it in writing.
Mm-hmm.
And
Yeah,
if you
you're
don't
right.
get it in writing, you can't just take their word for it. I talked to my neighbors. And we've had that on the city side several times where that's fine, they told you yes, but they're not here. And they didn't send a letter. So we can't take that as an okay for you. So make sure you get those things.
The other thing I would say on where you're taking written, I a lot of times suggest to go the step farther, in which that very sheet of paper that they're signing has a site plan on it.
Yep.
Or a picture on it. So the top half is what I want to do and showing it, and then the bottom half is that, so that they can't come back and say, that's not what I agreed to, because I've seen that in at least 3 counties before.
Usually best if you can get them to come to the hearing.
It is, yeah.
In reality.
I always suggest that they tell them that anyway, that please come to the hearing just in case there's a question for you. I'd say that's as good as testimony from your staff, because at that point, if what's going to happen,
And he notes it.
Yeah.
That somebody stopped in and he took the testimony.
Yeah.
So
yeah,
that's a miss.
you are taking the word of someone. You're taking the word of someone who, frankly, can be fired if he lies to you. So, and
I don't think
I'm,
he's going to make up a story for anybody.
yeah, I'm betting he likes to be fed more than to make stuff up. So, but that's a good point. It's something that we point out. We do point out correspondence. I suggest do that as well. Again, and honestly, I take a lot of page out of how that part, especially the correspondence, is handled here, honestly, and I show people to do it the way you do it here. I had haul roads on there. I'll just point out I've run into some cases back and forth here in this county. I know has had good history of working through things with haul road agreements. I've had some cases in the last handful of years in which a handful of people within a township don't want a project, and they find that the haul road agreement is kind of their Spartacus last stand that they can make against it. And I had bless one of the guys who was also opposed to something that happened, and he came into me after he had a meeting with his township, and he said, well, you won't believe what was going on. He said, well, I was in there, and they wanted to see the fields that the guy was going to spread his manure on, and then they started trying to tell him he's got to go to different fields. And he said, that's really not our deal, is it? I said, no. Your deal is, when are you going to go out and make sure the road is graveled? How are we going to determine that it's done right? It's if they want to go spread on those fields, that's their problem, but they better not ruin your roads, and they better fix them, and they better fix them the way you want them. You need to define what you want them is. That's more of what that document is. But we've run into some cases where that thing slowed down. I don't think that I can fully blame the townships in those either, because what the applicant thinks is a reasonable time and what the township thinks is a reasonable time are completely different, especially when an applicant is from Florida and asking for them to work on it during harvest or during fill in the blank time. Frankly, there's never a good time. It's either harvest or vacation or hauling grain or planting. There's always something. But bottom line is, we've had those cases, and in some cases I've seen counties just establishing some minimums and saying that, well, here's our minimums. How you make the sausage is up to you guys, but you better not ruin the roads. If we get a complaint about it, we're going to stop you. So anyway, I'll quit now, unless you've got a question for me.
Thank you.
Thank you all.
Very good. Thank you, Luke. Appreciate it. Moving on. Department reports. Richard?
We had letting the board know we've had longtime board member resign his position today. Daryl Nelson has resigned his position on this board. It will be coming up to the county commission. They will be advertising for a replacement for the remainder of his term. So if you know anybody in that district that would be interested or will be coming up during the county commission meeting in the near future. And also he sat on the joint jurisdiction subcommittee that is going over the joint jurisdiction between the county and the city. And it's up to the secretary or that board if they will fill that position, because it's been going on a year and a half that has been in progress. Is there a board member that would be willing to sit on that subcommittee if they decide to fill that? I guess you can let us know at the May meeting if you feel you would like to sit in that and fulfill the remainder term until that joint jurisdiction committee gets done and fulfilled. So, Tom?
What
And
are
we
the,
should, pardon me? Go ahead.
just for zoning purposes or whatever of where Daryl serves, what are the boundaries for that? In case I could, think of someone or.
Yep, it was District 4. Which is Trenton, Afton, Alton, the southern townships of Richland Township, Elkton, Parnell. I believe those are the townships that in District 4.
Oh, okay, because I thought Chairman Rochelle was in my area.
He is. He's in District 4 also.
Oh.
Mr. Nelson and Mr. Rochelle are the District 2 representatives from District 4.
Okay, thank you.
And we have a card here this evening. If you care to sign that, we're going to send Daryl. So, otherwise, the flooding's on the downward trend, so just be careful out there. And if you're on the township, we're going to be sending out packets to what you need to complete if you have any damage out there. If you do, just document and photo before you do any fixing, and then document and photo after the repair is done and completed, and then your cost estimate or what the cost of the repair of the repair was. So, and I believe that's all. Mr. Hill is in North Dakota at a seminar today, and he'll be back on Thursday. And I believe that's all we have. Spring is here. The May agenda is starting to fill up. So, Luke, you'll be off the hook for a while.
Yeah, I've got 8 items in Kynan County for my April agenda. Apparently we're 2 weeks ahead of you this year instead of 2 weeks behind you like we usually are on that.
So that's all that I have this evening.
I just need to make a comment on the joint jurisdiction. That goes for the county commission, probably more so. We do need, in that joint jurisdiction area, we do need some county representation, I think. So I encourage someone, if they have the time, to look at or think about getting on that board. Because we, like I said, we do need representation there. So with that, does
Maybe,
anyone have?
Luke, you can give them a quick update of where we're at,
Yeah, I
so
would.
that they
just
understand what.
so it doesn't
You
seem quite
step
so
into
daunting.
this, you know where we're at.
Yeah, the bottom where we're at on that is that there is a draft done. Frankly, a lot of it has been written in a form that is intended to follow how you've been doing things for years, only updating the language to actually say what you've been doing for the years. But the draft is largely done. We're down to just the last couple of conversations within that subcommittee group but they're larger points. Is there a need to have a small lot development district or ability to do so in small portions of the joint jurisdiction area? Is there some specifics about feedlot ordinances within that area and gravel pit ordinances, which have largely been decided with regards to that group? Now, don't forget, frankly, I anticipate they're at the point now where it's going to be tackle this topic, tackle this topic, tackle this topic. It seems to be taking one meeting for each, so I just named 3 of them. So guess what? I'm expecting about 3 more meetings is what I'm expecting before it comes to the whole planning commission. And I expect we're going to be sitting as a happy family, you and the city together, so we go through this once on the planning commissions, but I'm going to send it out to you, and if there is stuff that you don't like within it, guess what? You get to tell, because it's planning commission is involved in writing this. So bottom line is I'm hoping that we're down to about 3 more meetings. There may be a 4th to make sure that the language is happy to glad, is what I'm hoping.
I guess the point is, if we're going to have a representative appointed, we need to do that rather quickly. In the next meeting, we'll have to advertise it. That's the process, and we'll have to appoint. You may be there for 1 or 2 meetings as we get to the end of it. However, it's sometimes important to have that person because we need a quorum to conduct business. So I'd encourage you to find someone, and we'll get the appointment. But you may only have a couple of meetings left. But we're always concerned that we have a quorum to conduct the business. So we've been able to do that all but 1 meeting, I think, so far. So.
And the meeting I forgot to show up at.
Yeah, I wasn't going to mention that.
Yeah, that's right.
And you have been meeting, the ones I've been, have been in the mornings, like from 9:30 to 11:30. And that may change, but that's the time frame that they have been meeting on, is in the morning from 9:30 to 11:30. So they set the day during the meeting for the next meeting, but it's the same time depending on when they can meet.
Right now, well, our next meeting is actually Thursday. And then after that, I'm going to keep on trying to push for Thursdays, because my life is a whole lot easier if we do it Thursdays. But Tuesdays and Thursdays work a whole lot better for me. But county commissioner meetings make that a little tricky in the mornings. But anyway, I'm hoping for Tuesdays and Thursdays. We had been Wednesdays, though.
Well, just tentatively, is there anybody who thinks they might be interested? It's short notice, I understand that, but I guess not. We'll think about it. So is there anything else? The board have anything else? Otherwise, we're going to adjourn the meeting.
Does the member on the Joint Jurisdictional Committee have to be somebody that sits on the board normally?
No, I don't think so. Anyone could be anyone, so. Yeah.
That's what when we
Yeah,
filled
I
it, it
guess
was a
that's
sitting
what it was.
planning commission member that was on here.
Yeah.
It does.
So if he's an alternate, could he sit on that? Indirectly, yes.
I'd lean probably not.
Oh, okay.
But that's not my call. That's the county's call
Yeah.
as to how to do that. Frankly, I don't see why. From a practical standpoint, I don't see why not. But as long as that's someone who would ultimately be able to sit on the planning commission, because the idea is you're going to have a planning commission member that's going to be able to carry the water back to the planning commission and help to explain that a little bit. Here's what we were talking about. Now that person's already going to be behind the 8 ball a little bit. Thankfully, you've got Commissioner Bartley here, who's been involved in it from the beginning as well, to try and explain, here's what they were thinking, but that's, again, I go back to this county is unique in that our your alternates show up to all the meetings, so.
Could we as a board appoint someone?
Yeah. Well,
Can I make a
shouldn't-
movement?
I shouldn't say that, that's up to the county, that's up to how you established your. I don't think you had to for the planning board member sitting on it. It was just some at
No,
large.
we just asked for an applicant from this board to sit, if they would be
Right.
willing to sit on there when that was
in-
created.
Yeah.
I think you want to double check, but I don't have a problem. Tom would be good. I think you
We'll
check to
find
see if
out.
that'd be okay.
We'll do it at the May meeting. We'll find out for sure.
And I mean, on behalf of this board, like representing us, we're appointing someone. I don't know, legal jargon, but. Yes. Great.
We didn't vote on Daryl. Daryl just graciously did
Yeah.
it.
Yeah.
Okay, Richard pointed out the fact that we need to, next item on the agenda is the executive session if necessary. I don't believe we need an executive session, do we? Okay, and does anyone have anything else? If not, we need a motion to adjourn.
It would be Thursday. This, as in day after tomorrow. Yeah.
The county commissioners do.
In order to appoint someone, we have to have a full board, right? No? Okay.
We,
Well, exactly. That's what I'm
if we
saying.
need to appoint, but last time we did not appoint. We asked for a volunteer to sit on that board.
Right.
If the idea was that Tom would be okay by you, I think that you'd probably do it by just basically consent. If there was one of you that was okay with it, you just, unless someone else volunteers, then the only thing you do, you got to double check your because I think there were some rules or bylaws, you double check it, but at least if it's okay through that, then he's appointed if he wants, if he's interested. That would be, I'm talking about you like you're not here, Tom, sorry. But I mean, at least then, yeah, at least you don't have to come back together to do that.
Mhm.
Just as try and get something done by Thursday. Whether it's Tom, if it's an alternate, it's okay. If not, we can share it. It doesn't matter.
Yeah, it was a member representative from the Planning and Zoning Commission.
Well, I'm going to ask a question again. Okay, Tom's interested. Is there anyone else that has any interest at all or could make it to these meetings?
Tom,
Looks like Tom,
Unless there's an issue with it,
yeah.
in which case it's
If you want to do it, Tom, I want a consensus from the board, but are you willing to do that then?
Yes, I am, and if it's legal, yes.
Okay, all right. Okay, so let's just have a voice vote on this. All in favor of appointing Tom to the joint jurisdiction, say aye.
Aye.
Opposed? Carried. Congratulations. Yeah, I could be. The problem is time. Yeah, I could be.
The other question I have is, as an alternate like Roger, is there a term limit on my position, or?
That's in the decided by the county commission on their alternates on there. I believe it's 3 years, but we'd have to check on that.
Because I think I'm approaching 3 years, or maybe
We
even
time him
more.
out.
I don't know.
we time him out.
Yeah,
We'll check on that. We'll check on we'll have the commission check on that.
I'm pretty sure that that's going to be a short duration, so. Yeah. Okay, we got that done. I think everything else is taken care of. Does anyone have anything else at this point? If
How
not, we
long-
need to, pardon me?
How long had Daryl Nelson been on the board? He was before me. I don't
did
even
not
know.
get a chance to look that up today, but he was here when I started, and I started in 2005. Did he start with you, Bob?
I was on before him, but he's been on. I've thought about that, but I can't remember. But long before 2005, long before
That's
that.
private file.
chairman county commission, if Richard can get the official date, we'll present it.
There should be something. He's been on here a long time.
Yeah.
It'd be nice to officially see something for him.
I'd like to, this is not the time or the place to comment on Darrell Nelson, but Darrell Nelson, real short here, is he's done a tremendous job for this board, tremendous job. And without going into an hour-long speech, I think everyone will agree to what I just said. So, and that's where you're coming from, Darrell.
Yep.
So, okay. With that, make sure you sign the card for Darrell Nelson here. And we need a motion to adjourn. Motion by Ford, second. Second by McHugh. Meeting adjourned.